Dear viewers, today I have come to explain a few things to you about the civil litigation procedure in Zimbabwe. Um, in Zimbabwe, uh, if you want to file a claim against someone in Zimbabwe, let's say it's a monetary claim, if there is an agreement between the two of you, maybe the claimant or the plaintiff lend some money to a friend or to someone else. You want to, the person becomes a bad debtor, or in a way does not pay up during the time or within the time that you as parties you have stipulated. The best course of action to take, if there is an agreement, is firstly to look at the terms of your agreement. If the agreement says in the event of a dispute, the wronged party is going to go for arbitration, then you have to go that way. But if in the event that the agreement is silent on the issue of the forum in which one can launch or can actually file a claim, then the best way to do it is to firstly write a letter of demand to that person, giving the person 7 days within which to pay. That is trying to rectify or trying to remedy the breach of the agreement between the two of you. If the person does not comply, then you will have to file a summons in the magistrate's court or in the High Court of Zimbabwe, depending on the monetary value involved. In Zimbabwe, magistrate's court have certain jurisdictional limits, and those jurisdictional limits will make it impossible for the magistrate's court to adjudicate on matters that have monetary values which are above the stipulated amounts. So what it means is you have to check whether the amount that you want to claim from someone is within the jurisdictional limit of the magistrate's court. If it is not, then you will need to launch your claim in the High Court, but the letter of demand part must not be skipped. So what it means is that after the letter of demand, you look at your claim and determine which forum is the most appropriate for your claim. After the letter of demand, you launch the summons either in the High Court or in the Magistrates Court. After the summons, the defendant or the person against whom you are making the claim may choose to file an appearance to defend. If that happens within 7 days, then that you file what is called a notice to plead in the magistrate's court, or a notice to plead and intention to bar in the High Court. In the magistrate's court, it gives 5 days within which the defendant must file their plea, and a plea is an answer to the plaintiff's claim. The plaintiff is the one who is claiming the money. You get me right? You have to understand this. The plaintiff is the one who is making the claim, the one who is demanding for his or her money. So, in that scenario, the plaintiff must file what is called a notice to plead in the magistrate's court, or a notice to plead an intention to bar in the High Court. If in the magistrate's court, If the defendant fails to file either an appearance to defend or a plea, the plaintiff can actually request for default judgment. And when that happens, it means that just a moment, briefly. All right. Okay, comrades, I'm back. Uh, we're talking about filing a notice to plead or a notice to plead intention to bar, depending on which forum. Notice to plead in the magistrate's court, notice to plead intention to bar in the high court. Then I talked about in the event of failure by the defendant to file his apparent defend or plea, the plaintiff has to request for default judgment. Default judgment is a judgment that is given in the absence of the defendant, that is, in the absence of his apparent defense or in the absence of his plea. In the High Court, once the time given on the notice to plead in the intention to bar has lapsed, the defendant is barred from filing any document unless he or she applies for the upliftment of bar. And that's another process I'm talking about. Today I'm presenting on action procedure. Action procedure is that process which starts with the letter of demand, the summons. Now we're at the stage of appearance to defend, and then the issue of request of default judgment and the barring of the party that may have failed. But in the event that the defendant actually complies, files an appearance to defend, you file a not you file a not to plead the intention to bar or a notice to plead, they file their plea. After they file the plea, the plaintiff files what is called a replication. And when the replication is filed, uh, some parties can actually deem the proceedings closed. That is when you begin to prepare the so-called pre-trial conference papers. In Zimbabwe, nowadays, the new rules in the magistrates court, the new rules in the high court, they require the parties to find each other first. Actually, it was a requirement long ago, but not as serious as it is now. They require you parties to find each other, try to iron out certain issues so that you can curtail proceedings on the trial date. So what it means is that on the issue of after you prepare pre-trial conference documents, that is the notice of set for pre-trial conference, the pre-trial conference issues, the issues are the ones that will be stating the triable issues. For example, whether or not the defendant owes the plaintiff a certain amount of money. Then we talk about discovery affidavit, the discovery affidavit. The discovery affidavit will be talking about the documents that the plaintiff has, which uh, he can use to prove his claim, or then the plaintiff files such a discovery affidavit, the schedule of documents that he may have. He serves the other party, that is the defendant. The defendant also has to file a similar set of documents. If he has the documents, you will have to attach them to the schedule of documents and serve on the plaintiff. But before this whole issue of filing of papers, the parties must engage in a party-to-party meeting before they even come before a judge or a magistrate. They have to iron out certain issues and file what is called a joint pre-trial conference minute, which may then be incorporated, or which may form the issues that will be referred for trial if there is need. Certain at times the pre-trial conference meeting, that one between the parties can actually make the parties realize that they don't need the court in order for them to resolve their issues. Others can actually file a deed of settlement, and the deed of settlement is when they will be agreeing. Maybe the defendant will be saying, no, I will pay the plaintiff this amount. Maybe what was stopping him from paying was maybe the confusion as to issues to do with interest or the agreement, the payment agreement. So in such a scenario, or maybe some financial constraints may have hit the defendant, but the plaintiff may understand during that meeting that no, it wasn't, it was something beyond the defendant's capacity, beyond the defendant's capability to pay, or some other reasons that are understandable. And once that happens, uh, an understanding has been struck, then there will be a deed of settlement in the High Court and an order by consent in the High Court. In the High Court. So, in such a scenario, uh, when that happens, the matter may have been finalized. What remains of the parties is to go and collect the order, and after collecting the order, the parties must be bound by the order that has been made by the court. If it happens that the matter goes to trial, a trial kicks off, the plaintiff presents his case, the calls upon his witnesses to testify, documents are produced in court, the defendant then proffers his own defense, he produces the documents that proves his own case, and it disproves the plaintiff's case. Then the magistrate or the judge makes a determination that one of the parties is not satisfied with. The party, I will start with the magistrate's court. The party in the magistrate's court, the plaintiff or the defendant who is not satisfied, can actually launch an appeal or file an appeal with which lies with the High Court. So an appeal from the magistrate's court goes to the High Court. Then an appeal from the High Court goes to the Supreme Court. If there are then constitutional matters that arise during the proceedings, they have to be referred to the Constitutional Court of Zimbabwe. But the process needs another day for me to explain. The issue of referral of matters to the Constitutional Court, that will need its own lecture. That will need its own day or its own stream, because it has many complexities in terminologies that may need me to clarify and try to simplify so that everyone can understand. I thank you for watching this video. I thank you for being in this live stream. Next time I'll come with a video explaining what is called application procedure. Today I explained what is called action procedure. Maybe I'll go a little bit back uh, after the appearance to defend, that stage. We say someone's appearance to defend. If the defendant cannot be able to plead based on facts written in the particulars of claim or the plaintiff's declaration, they may seek for further particulars from the plaintiff, who must proffer the further particulars, of which sometimes defendants can just ask for further particulars out of malice just to delay. But there are also genuine requests for further particulars. So in such a scenario, the plaintiff has to proffer uh, the further particulars. Maybe the plaintiff will give inadequate uh, further particulars, and by further particulars I mean facts which must sufficiently explain the plaintiff's claim. Now, if the plaintiff gives some vague further particulars, the defendant can actually ask for further and better particulars, which the plaintiff must uh, um, proffer. In the event that the plaintiff fails again, then the defendant can actually uh, seek for or it can raise a point that a point in limine or a legal point that the plaintiff's, especially in his plea, the plaintiff's claim is vague and embarrassing. So in such a scenario, as much as the plaintiff may push to go for trial, they will already know where their claim or their case falls. Which means when the defendant requests for further particulars, the plaintiff has to properly explain what is required of them to present. Thank you.